In 2021, New York City announced it would stop paying Medicare supplemental insurance for city retirees and would be switching them to a federally funded and far inferior type of insurance called Medicare Advantage. The city attempted to spin this as an improvement and emphasized the municipal budget savings of $600 million a year. Mayor Adams called the savings a crucial cushion against expected budget deficits, but the savings are dependent on the city charging a $192 monthly penalty on any retiree who chooses to stay on the traditional Medicare coverage instead of accepting the new plan. The New York Organization of Public Service Retirees banded together and sued to protect their right to Medicare supplemental insurance. And in November of 2022, the Manhattan Supreme Court found that the financial penalty contradicted Local Law 12-126 that requires the city to provide retirees with premium-free health coverage for life. Now, Mayor Adams' administration is appealing the ruling, contending it was complying with the law as long as it offers the Advantage plan for free. Let's take a look.
Matter of New York City Organization of Public Service Retirees versus Campion. Counsel?
May it please the court. I'm Richard Deering for the city. Your Honor, I'd like to request 3 minutes for rebuttal, please.
Yes, sir.
The injunction below suffers from two distinct errors. First, it misunderstands Administrative Code 12-126 to impose a mandate that if the city makes the senior care plan available, it must pay for it. Second, and alternatively, it misconstrues the cap provision in the ad code. I'm going to start with the first of those arguments. Try to make three sort of broad brush points. One textual, one kind of practical, logical, third that's a little bit of a meta point or a framing point about how to approach, I think, a statute like this one. So the text, what does the text do and what doesn't it do? What the text does, it confers, we acknowledge, a very significant and also very specific benefit, which is to say that the city must provide a premium-free healthcare plan or premium-free healthcare coverage for not just for people during their working life at the city, but their retired life throughout the entirety of it and for their dependents.
So let me just ask you, sorry, right in front of you. The city, the way that healthcare benefits are provided is through collective bargaining.
Correct.
And that was true from the 40s or somewhere long before any of this, right?
There was, I don't know about the 40s, but there was collective bargaining predates this local law, and you can see that in the Board of Estimate resolution that you see in the record.
And so is a way to look at at 12-126 as a restriction on bargaining positions the city can take?
I think that's fair, and the question is, what are those restrictions? Right. Yes, I think that's fair, and in fact, I think a critical and important way to understand 12-126 is that bargaining over health benefits predates that statute. The content of our health offerings has been determined by bargaining. 12-126 doesn't speak to that.
Is there something in the record which confirms that you're paying for the multiple, you have paid for the multiple plans solely as a result of a collective bargaining obligation? Or is that not your position?
I think our position is that, I guess the way I would say it is that I don't think the record is quite that specific. What I would say is something a little bit different. If you look at, it's clear that the city had paid for multiple plans before 12-126 existed. So I think what that shows is that, and that practice, as I understand it, it predated 12-126, and it has continued via collective bargaining after 12-126. You can see that if you look at the Board of Estimate resolution, you will see in the recitals of that resolution multiple agreements referenced.
And the city actually bargained for a provision of benefits that paid for 100% for multiple plans before that was, the city was authorized to do that under state law, is my understanding.
I think that's...
And the statute had to be enacted retroactively to cure that 6-month period.
I'm not sure, so. That might be right. It's close in time on the state law, I think, but I definitely think it's clear the bargaining comes first. So what I think is very clear is that there's nothing in the record that suggests that 12-126 was the impetus for paying for multiple plans.
So what is the significance then of just past understanding and past practice with respect to providing multiple plans and having the payment scheme in place that existed prior to this latest development?
I think none, because of precisely this point, that there were multiple agreements reached through collective bargaining. A key thing that you will see in 12-126, 12-126 doesn't say I guess, let me just take a step back. It's important to understand what collective bargaining and what the Board of Estimate what kind of thing it was, and what kind of thing, for lack of a better word, 12126 is.
Sorry, what's the "it" in the first point that you made? What a thing it is? I just want to make sure I get the antecedent.
What the Board of Estimate resolution and collective bargaining does. So what those pieces put together, and it starts with bargaining, is to identify plans and to say you'll be offered a choice of those plans. And then the bargaining also said we will pay for those plans. 12126 comes in and only does that third thing. It says you will have to pay 100%. It doesn't say anything about choice of plans, let alone say what those plans would include. And that's not surprising because, it's quite one thing to say in a particular bargaining cycle,
So
we're gonna.
if just looking at the plain text, tell me what words make it clear that you only have to pay for one plan.
Well, I'll say two things, and I just want to preface the answer with this. I don't think this turns on necessarily whether it has to be only one plan. The key thing for our position is it doesn't say that we have to pay for every plan we make available. I want to try to unpack
I'm not
that.
sure I understand the difference, but just,
I'll try to
again, let's
unpack
get back
it.
to my question.
Sure.
Where's the language that supports your position that you don't have to pay?
I think it's-
I think the position now you're saying, we don't have to pay for every plan.
We've said both of those things, and I just think it's the second is all we have to defend to win this case, and that's what I want to home in on. I think it's more what the statute does not say, and I think more than what it does say is what it does not say. And I think this first
Don't
point is,
usually look at a statute that way.
I think we often do, actually,
Well, I'm not so sure we're going to do that here, but go ahead.
Okay, well, I'm going to do my best. Let me try
All
to
right.
convince you of that.
Fair
What
enough.
the statute doesn't say, right? And I think this is undisputed. It does not prescribe which plan or plans the city must offer. That's clear. I think that's conceded. It doesn't do that. And Justice Frank said, you don't have to offer senior care, right? The second thing it doesn't do, and I don't think there's any language that does this, and when you're looking, I think, at a statute that you're going to read to constrain the collective bargaining process along the lines of Your Honor's question and impose financial obligations on the city, it's about what the statute does say and doesn't say, not that we don't have to refute the obligation, they need to establish it.
So-
And the second,
Okay, but it
So
says,
A-
I'm sorry, it does say entire cost, which you're not debating that, of health insurance coverage. It sounds to me like you interpret that to mean not all plans, and I don't see how you get that from health insurance coverage.
I'll give you, I'm going to try two things on that.
Okay.
Can I just append a follow-up to that very question? A4 mandates a program of health insurance coverage, which, as I understood it, means a suite of available plans, not just one plan. So how do you get to this, to the extent that you're arguing that we only have to provide one plan or pay for one plan, how do you get there with that language in A4?
There are two levels to this, all right? I don't read A4 the same way. Justice Frank didn't read it the same way. And I think if you substitute it into the statute, it really doesn't make sense read that way, because the thing you pay for at the end is a plan. The thing you pay a cost for is a plan, and so when you substitute it into the statute, that's the better reading. But I really want to get to my second point, because I think this is the key point. No matter how you could read program as I think about it three ways, maybe. You could read it either to mean or be satisfied by one plan. You could read it to mean one plan per category, maybe, or you could read it to mean more than one plan per category. And under any of those readings, I think we still win this
So
case.
what does a program of hospital, medical, surgical insurance mean? What does the word program
Well,
mean?
I'm going to tell you, you could read it, and this is the point I really want to get to because I think it's the crux of our position. You can read it if you wish. I don't think it's right, but to say that it requires more than one plan per category of insured. But the thing that it doesn't say is that the program, the 12126 program, the program that's made available free, has to include every single plan we offer. It says a program. It doesn't say the program. It doesn't say a program that includes every single plan. And I just want to move to my second point, which I think is more of a logical, practical point, not a textual one. And it's really, this is a variation on a greater includes lesser argument on our part. Now, it's true, it doesn't always, but it usually does. And I think a key point, the first key point is 12126 does not compel us to offer senior care at all. I don't think there's a dispute on that.
Well, if we think that the program is ambiguous and we turn to the legislative history, can you find support in the legislative history for your position? I find it difficult for you.
I think we have a lot of support in the legislative history, and I think the legislative history they rely on is quite suspect. And let me make 2 points. But if I could, I just want to put a fine point on the idea that there's no dispute that we don't have to offer senior care at all. That's the greater, and the greater includes the lesser. And the question really is, why is the statute appropriately read to bar the lesser step of saying we'll make it available on an opt-out basis, purely opt-out basis. We're going to have a 12126 program that we pay for. You can opt out of that and pay for senior care. Why does the statute forbid that? Let's talk about the legislative history. The most significant thing, there was a prior version of this bill that did something that did include text that goes much closer, if not all the way, to what petitioners are asking for. That's at 1324 of the record. That said the city's obligation would be to pay the entire cost of any basic health insurance plan. That's what it said. Mayor Lindsay, they passed that. Mayor Lindsay vetoed that bill. And in a veto message that is worth reading in full on record, page 1326, the mayor repeatedly hammered again and again the idea of open-ended and unforeseeable financial consequences from the city from that language, and the bill was thoroughly rewritten after that veto.
But wasn't that only as to the statutory cap?
It's not, and if it were just about the statutory cap, what they would have done is continue to use any basic health insurance plan and add a statutory cap. But that's not what they did. They fundamentally rewrote the statute. They didn't keep that language in that Mayor Lindsay had objected to any basic health insurance plan. That language was scrapped, and it doesn't appear anywhere in the bill that was actually enacted.
Does it say one plan only?
It doesn't, and I'm trying to make a different point, which I mean, we think program is better read that way, but I'm trying to make a different point, which is that even if you disagree, what it clearly doesn't say is that a program as defined here.
So your argument is premised on what's absent.
And I think entirely appropriately, because this is a statute about imposing a fiscal obligation on the city.
So what exactly do you think was behind, what was Lindsay's concern exactly?
Lindsay's, in his veto.
Yeah.
He said three things. He said, this would require us to pay for coverages which the city cannot possibly now anticipate. He even objected to the language in the bill that said, that the bill as originally written said, you're going to pay the Part B premium. He said, that's the problem. Right now it's $3. You should say we'll pay $3. And what he said was, we're unable to foresee or influence what that premium is going to be. We shouldn't be committed to it. And he said, I would accept a bill that achieves payment of the Part B premium, that's what he said, without exposing the city to unforeseeable and possibly unwelcome demands on its financial resources. And that's precisely the situation that we find ourselves in now with.
And then it was rewritten to fix the $3 as a number.
Written to fix that. It was.
No, I mean, what was put into the revised bill was $3.
It was, and many other things.
Right,
This bill was
right.
thoroughly rewritten from stem to stern after this veto.
So I hear an implied answer to Judge Rivera's question, because I too would ordinarily say, what does the statute require on its plain language? It sounds as if if you were forced to answer that question, which you haven't yet been, but I'm going to try, you would say that program is defined as a combination of hospital, surgical, and medical benefits. That's a program, and the statute requires you to provide a program.
That's correct.
And if you provide a program, that's you can't, if we can think of this in the collective bargaining framework, you can't offer less than that.
That's correct.
You can be bargained to require more than that.
Precisely. That is the minimum obligation that is codified in the statute. We satisfy that obligation, and I think the way to see that, we can do more, as you say, in a collective bargaining. The way to see that we satisfy
You have done more. You did more historically.
We've done it historically, right.
But your position is that's a function of the collective bargaining obligation, not the statute.
When we have done more than the statute,
Yeah.
that's our position, and as I said, it predates
But then
the statute.
why in that provision, right, does it refer to contracts in the plural and companies in the plural?
I have two answers. One is many plans, including senior care, and including all the plans the city that were offered pursuant to the Board of Estimate resolution had multiple contracts with multiple companies. All of them did. It doesn't really tell you anything about one plan or more. I will note, again, the object of program is not a program of plans. The object is a program of benefits, entirely consistent with being one plan per category. But I think the most important point, and where I want to try, to stop, to draw the backstop of this argument, is that it clearly doesn't say that this program, this minimum obligation that we must meet, has to include every plan we offer. And I just want to put it this way, one point, and then I'd like, if I could, to talk about the cap for a minute, maybe.
So let me be clear about that. And by the way, I'm not so persuaded on your other point, because then, following your analysis, that we look at what's, we listen to silence rather than to what is affirmatively spoken said out in 12-126. One would say, if that is true, you got contracts and companies of multiple per plan, that then one would say plan, not contracts and companies. So it seems to me it undermines your argument. But fair enough, that's your position on that. But I'm still having difficulty sort of understanding how the beginning of the provision that's talking about coverage, as opposed to just saying a plan, and then putting a cap, doesn't lead one to the place that it is really talking about whatever plans you offer, you have to pay for them, versus on the one side you're arguing, no, it's only one plan, but no, it's not only one plan, it could be multiple plans.
I'm just arguing that there's multiple layers to our argument. I don't think there's anything
No, I understand that, but I'm having
unusual or surprising about that.
difficulty, I'm having difficulty making my way past the plain language. That's what I'm saying to you. I know you're making your argument. Perhaps you've persuaded everybody but me. But I'm just a little unclear. If you're saying it could be more than one plan, what then you mean by that?
Well, I think the better question is for petitioners, what do they think that means, right? Because what
Okay,
it doesn't
well,
say.
I will ask them too, but I'm asking you.
This is a key point, because what it does not say, in contrast to the Board of Estimate resolution, which is about products of collective bargaining and about, a specific policy, not a codification of something into the future, what it doesn't say is what those plans need to be. And that is a gaping hole, I think, in their argument. And here's the reason, here's the way to see that. If we ignore senior care, if we just ignore senior care, and we look at the other plans that we're paying for, we meet the minimum obligation of 12-126, right? I think that's clear. And now if we just ignore it, if we got rid of it, we meet the obligation of 12-126. But now if we bring it in and say the following, purely in your election, you can reject the free plans, and on an optional opt-out basis, just like you can opt to reject city health insurance altogether, you can opt out and pick a plan that you pay for. Now we violated this minimum obligation. Before, we've added something, and yet we were in compliance with the minimum obligation in the first instance, and now we run afoul.
I know your light's on, but if I could just ask you to briefly address the relationship between whatever is before us in this case and Benkowski?
Sure. I think there's a significant interaction, right? So what's before us in this case is what I've tried to home in on here. The crux of the ruling below is that we don't have to offer senior care, but if we do, 12-126 imposes an obligation to pay. There's another question about the statutory cap, which I haven't quite gotten to yet. Benkowski is not rooted, as it comes to your court, and obviously we have a leave motion there. We think it is, if any case is leave-worthy, that one is. Benkowski is not rooted in 12-126 in the First Department's ruling. It's rooted in a promissory estoppel theory, which held that as a result of promissory estoppel, based on our summary plan descriptions, the city has an obligation to provide a Medicare supplemental plan. It doesn't say it has to be senior care. It says it has to be a Medicare supplemental plan, which meaning our offerings on the side of Medicare eligible plans cannot only include Medicare Advantage plans.
Let me just ask you to take 2 minutes on the cap, because it would probably help us to hear that before we hear from council.
2 minutes on the cap. So I think the cap point is really pretty simple, and it is that it doesn't make any sense, and nothing in the statute says that, you would have to see something very clear in the statute, and you don't, to say that the appropriate cap for a group of Medicare eligible individuals is determined by a plan for non-Medicare eligible individuals. Insurance for non-Medicare eligible individuals and insurance for Medicare eligible individuals are two completely different animals. Fundamentally different insurance, fundamentally different cost profiles. The record shows this abundantly, and it's just simply not an apples-to-apples comparison of any kind to say that when you look at Medicare eligible individuals, you're going to determine the cap by reference to a non-Medicare eligible plan they couldn't even enroll in if they wanted to, and a plan whose economics are fundamentally categorically different from plans for Medicare eligible individuals. And I think the language of the statute, as I said, it would be surprising to reach that result. You would need something pretty clear in the statute. There's nothing clear in the statute, and every textual indication there is in the statute cuts for us.
As to that cap issue, where did you preserve that in the record?
We preserved it. We raised it.
Where?
I'll give you the sites. We raised it. This is in Supreme, because I think that's the only place there's a question of preservation. We raised it for joint issue abundantly in the appellate division. We raised it in a letter after oral argument. It's R 1970 to 1971. Petitioners responded to that letter. That's R 1972 to 1974. And the court reached the question. The court, in its opinion, listed all the there were also two amicus submissions that dealt with the cap. That's ECF 205 and ECF 208. The court listed all four of those submissions. That's R7. And the court reached the merits of the cap question. That's R9. So I think from the standpoint of preservation, it is preserved under this court's cases. If I could circle back just a second to the text of the local law, because I think we win even before you get to these textual points, but I want to unpack the textual point. The law says that the cap is determined on, quote, on a category basis, unquote, which makes clear that it's meant to be apples to apples. And if you look at a rate sheet for our plan rates, you will see lines and boxes, and they might have individual, they might have family, and they might have Medicare. They're all separated out. They're all different. They're fundamentally different economically. And when you make clear that the cap is to be determined on a category basis, I think it only underscores the correctness of our position on the cap. The other thing I would say about the cap is that the language enacted by the City Council in 1967 specifically refers to health insurance coverage predicated on enrollment in Medicare. So
I'm sorry, where in the Supreme Court opinion do they address the cap?
This is the part I'm referencing. It's at R9.
Okay.
It says the following. It is the court's understanding that threshold, I'm not going to say he addresses it at great length, but this is what he says. Justice Frank, I should say. It is the court's understanding that the threshold is not crossed by the cost of the retiree's current health insurance plan. This is buoyed by the fact that the current plan has been paid for by the respondents in full to this point. So he did not hold that the cap issue was unpreserved. By my lights, he reaches the cap question, and that is how he resolves it.
And threshold means cap in your reading? Is that what you're referring to?
That is what it means in the context of that opinion. That's correct. I have one point of update for the court on I don't think this is pertinent to the statutory construction question, but I think it's appropriate to update the court, that for the last 3 years, the rate on HIP HMO for Medicare eligible individuals has been $750 per person per month. The tentative rate for the upcoming year has been increased dramatically to $198 per month. Still $26 below the rate for senior care. In our view, that really reflects on the one hand, the effects of the productive competition that the Medicare Advantage initiative brought to this entire equation for the last 3 years, and the fact that it's been blocked for 3 years, and HIP has increased its rate for its HMO plan. But I just want to make sure the court is aware of that.
Thank you.
Good afternoon, and may it please the court. Jake Gardner of Waldemocht, Heron, and Williams for the respondents. I can explain in 4 sentences why this court should affirm. Section 12126's authorizing statute, General City Law, Section 20, subsection 29B, allows the city to pay certain costs for its retirees' health care if and only if the city offers, quote, a choice of health plans program. So the city has to offer a program with a choice of health plans. And that is what the city has always done through its health benefits program. Section 12126, by its plain terms, requires the city to pay the entire cost up to the statutory cap of that program, not just one plan within the program. So I know this court was very concerned with what is the meaning of program. It is the entire, like Your Honor said, the entire suite of plans. It has always been understood. The program is a term of art, distinct from plan. And the city has always offered a choice of health plans through its health benefits program.
So I want to make sure I understand your argument, which is that state law would prohibit the city from paying for 100% of retiree health care unless the city provides a choice of plans.
The only way that Section 12126 is allowed to exist and allows the city to pay for retirees' health insurance, including the Medicare Part B premium, is under General City Law, Section 20, subsection 29B, and it says that there has to be, the city has to offer a choice of health plans program. So that phrase right there, it's very clear that health plans are different than program. And once it offers, I agree that 12126 by its terms.
I'm sorry, so what is your understanding that the legal consequence would be if the city chose to offer only one plan?
If the city chose to offer only one plan, which is essentially what happened after this case in Benkowski, that's unlawful for a number of reasons that aren't before this court. And I don't want to get ahead of myself and start arguing Benkowski to you, but
Well, I
it
don't
is
mean
unlawful.
Benkowski, but you just read me a statute,
Yeah.
I think, that would suggest that the city lacks the authority to offer a single plan.
That's
Or-
a plain reading of General City Law, Section 20. It says that in order,
And is that an argument you made previously?
yes, we note in our brief that the term program refers to all health plans because General City Law, Section 20 allows the city to pay certain costs for its, quote, we actually, in the brief, we say health plans program, but if you just read the previous two words, it says choice of health plans program. But regardless, the point is that program encompasses, it's not a plan, it's the entire suite of health plans.
Is it your position that the city is statutorily obligated to provide a Medigap plan as part of the program?
It is, but that's not an issue before this court. In this case, the city has offered Medicare supplemental insurance, and the only question is, given that program, does it have to pay up to the statutory cap for all of those plans?
So I thought I read the papers, and correct me if I'm wrong, to say that at least here, the parties were not disputing the fact that the city could choose to provide just one plan.
So under the
I'm just asking if you said that in your papers.
no, we certainly did not say that. It has to offer a program of plans, and the facts in this case, the factual record is that the city was going to offer a program of multiple plans. And so the only question is, when it does that, does it have to pay up to the statutory cap for that program or for just a single plan of its choice?
But that's different than whether they are in fact obligated to offer more than one plan. The question of whether they have to pay if they do offer is distinct, no?
That's correct. The question is whether they have to offer multiple plans. Wasn't briefed. Our position, it has to offer a choice of plans. The question is what those plans are. That was an issue in Benkowski. And in Benkowski, the question is under Section 12126 and through common law principles of estoppel, does the city have to continue to offer Medicare supplemental insurance? And the courts below all decided that the city does. The question in this case is very simple. It's what does program mean? And there's nothing in the legislative text or the history that suggests that program is the same thing as a plan. And I'll add one other note. If you look at Section 12126.3, it makes reference, it uses the term health insurance coverage.
Well, it says a program of benefits, right? That's what program modifies.
That's correct. And program is, as the authorizing state statute indicates, and also if you look at the legislative history, it says.
And I'm just looking at the text for a moment. So why isn't the plainest way to read a program of hospital, surgical, medical benefits to mean the program is a set of benefits that includes hospital, surgical, and medical.
Because
So,
that,
for example, it wouldn't be a program of hospital, surgical, and medical benefits if it didn't cover hospitals.
so elsewhere in the statute, it talks of a health insurance plan. And under principles of statutory construction that this court has repeatedly acknowledged, when you have different terms in the same statute, it's reasonable to assume that different concepts are intended. And that's especially so here, given the fact that the legislative history says the city's health insurance program offers a choice of 3 plans. That's record site 1339. I'll also note that Mayor Lindsay, at the time, he issued a statement about the legislation, and this is what he said. He said the city's health insurance program offers a choice of 3 different health insurance plans. Given that and what I said about General City Law, Section 20, program and plans are not to be confused. They are 2 different things. I will also note Section 12-126.3 uses the term health insurance coverage with reference to 12-126, and it talks of the program of hospital, surgical, medical benefits provided to participants therein. Participants is only used when you're talking about the health benefits program. No one says, the city council never said participants when it was talking about a plan. A plan has subscribers. If you look at record site 89 and 320, again, it talks about participants within the health benefits program. So I think that's further textual evidence, granted in another part of 12-126, that supports our interpretation. I'll also note we haven't talked about the city council report that was attached to the final version of the bill that became 12-126. And I don't think there's ever been a report that so decisively answers the question before a court as this one. This is what the City Council Committee on Health and Education said on record site 1327. This bill would provide that the City of New York pay for the entire cost of any health insurance plan providing for medical and hospitalization coverage of employees and retirees.
That's actually the language that was omitted from the prior draft, right?
That's the language that was in the report of a prior draft, and the reason why they kept it is because
Well,
even
how
though
do we know that?
Well, here's why. If you look through the sequence of events, there was an original version, like my colleague, like my adversary said, that said any basic health insurance plan, and Mayor Lindsay took issue not with the term any. His focus, if you look at 1326, he said there were technical defects, and one of them was that there was no definition for the term basic health insurance plan, and that would create a problem because there would be no cap, predictable cap. So what the city council did was they simply provided a cap for the city's payment obligation tied to the same plan that was...
And took the word any out.
They took the word any out, but they used the term program. So they basically just they just described it through a different mechanism. If they had suddenly dropped any, that would have radically altered the basic premise of this legislation. And there's no indication that the city council somehow just did away with the term any when Mayor Lindsay took no issue with it. It would have been very surprising for the city council, who was aggressively pushing for the broadest possible legislation, to suddenly do away with a basic premise of this legislation when Mayor Lindsay himself took no issue with that. It's true he took issue with the fact that there was no definition, there was no cap. And so the city council responded by providing a definition and a cap, which comes right from Resolution 292, which I think we all agree required the city to pay for all 3 of the plans that comprised its health benefits program at the time. So the key point is that Mayor Lindsay had no problem with the term any or the city's obligation to do as it had been doing under Resolution 292. His only concern was, you have to give me some sort of predictable cap going into the future, and that's exactly what the Committee on Health and Education did.
Going back to the text, what, if any, work, in your view, is the word contracts doing here?
I think it's doing a lot of work, Your Honor. And as we explained in our brief, the city says, just in a conclusory fashion, that you can have a single plan with multiple insurers pursuant to a single contract. There's nothing in the record. There's no documentation that indicates that a single plan can be executed pursuant to multiple contracts. In fact, the only documentation in the record is the MAP, the Medicare Advantage Plus plan. And there you have 2 insurance companies who have a single contract with the city. So I think the word contract does a lot of work, although it doesn't have to, given the word program.
But is it the case you could have a single program For example, could you contract separately for the hospital benefits from the medical benefits?
I don't know if it's possible. That's beyond my knowledge. I just know that by using the term contracts and companies plural, I think you should contrast that with the language used in General City Law Section 20, which was designed to give the city maximum contracting flexibility. There, unlike in 12-126, the language that the city drafted, because it was a legislation through home rule request, was contract or contracts with, quote, one or more insurance companies. So the fact that in 12-126, the city contemporaneously decided to use the plural exclusively gives you an indication that that use of the plural was a deliberate choice. And it reflects the city council's desire for the city to pay for the whole program, which it has done for 56 years. And another important point, Your Honor brought up collective bargaining. There is nothing in this record or outside the record that I have seen that says that the city is going to pay up to the statutory cap for all plans based on collective bargaining. There are collective bargaining agreements in the record. If you look at record 168 to 330, 443 to 640, 725 to 838, not a single one of those collective bargaining agreements mentions the city's obligation to pay for senior care or for all of the plans in the health benefits program. That obligation comes solely from Section 12-126. So on my adversary's rebuttal, I would like to hear where in the record there's any support for the notion that this is done through collective bargaining as opposed
So the way it would be done would be to get the city council to amend the statute, right?
Exactly, Your Honor, and that happened. After our victory below, Mayor Adams' administration lobbied the city council hard to change Section 12-126. And the city council, which is responsible for balancing the city's budget, so it's very well aware of any sort of budgeting concerns here, refused that, just flat out refused it. And I think that's an indication of where the city council, who they should be the ones, if there's an issue with how this is interpreted, the city council would be the logical place to fix any supposed problem. The city council has refused.
That's the council of today. We're trying to figure out this statute, which predates the council of today and the request of today, right?
That's correct, although I think it's interesting that we actually have a sworn affidavit from a former city council member, Barry Salmon. He submitted an affidavit that's unrebutted that said, I sat on the city council right after this law was drafted. I also voted on various, he voted on various amendments.
We generally don't put a lot of weight on a statement like that, do we?
I don't know if this court does. I just want to note it since it arose. But I do think one thing that is interesting is the city itself. I'm not sure if this court is aware of who Stephen Lewis is. He is the leading expert on the administrative code. He was with the New York City Law Department for 40 years, including as chief of legal counsel. In 2016, he wrote a memo that said, and I'm quoting, "The administrative code requires that the city, with respect to any offered plan, pay up to the full cost of HIP HMO." And I think that it's telling that in 2016, before the city had an incentive to try to interpret the statute in a way to its liking, it was saying internally.
It didn't say every, right?
And any offer
could
plan.
mean whatever you offer, and that could be one, as opposed to every. Now, you'd have a much easier go with it if it said every, I think.
There's actually, we cite in a footnote in our case, this court has held repeatedly, the court said, that the word any means every, all and every. So this court has held, and I'm sorry I can't remember the exact footnote, but we cite the Court of Appeals decision saying that the word any means every or all.
As used by a lawyer in a memo?
We also cite a case that's saying that the legislature should be assumed to understand these past holdings, which began well before Section 12-126 was enacted in 1967. So I do think that the fact that the city has always interpreted for 56 years this statutory provision to require them to fund all of the plans in the health benefits program, I think that's incredibly telling.
Counsel, I see your light's on. Could you just briefly address the preservation argument for the cap?
Yeah. So I don't have a major disagreement with how it was described before. It was after briefing and oral argument on the dispositive motion below. The city filed a 1.5-page letter the night before the court said it was going to issue its decision, basically saying for the first time ever that, guess what, HIP VIP, the HIP VIP Premier Medicare plan, sets the statutory cap and it's $7.50. I was the one who wrote the letter in response the next morning, scrambling, from my apartment in the middle of COVID, just objecting to the fact that this was basically an ambush and it was procedurally improper. The court then issued its decision just a few hours later, and it didn't grapple with the issue at all. In its decretal language, the court simply held that the city has to pay up to the cap for whichever plan retirees choose. If you look at the bottom at that decretal language, that's all it held. It noted in passing, in the language that my adversary referenced, that it was its understanding that the cap did not exceed, or that it did exceed the cost of senior care, because that was undisputed for 6 months of litigation. And we noted in our papers and at oral argument repeatedly that there's no dispute by the parties as to what that cap is. So that's, of course, why the court just gave it the back of the hand and said, that's my understanding. This was undisputed below. To say that you could submit a letter past the 11th hour.
I'm sorry, that meaning that whatever the cap is, the parties agree that senior care does not exceed that cap. Is that what you mean?
Yeah, well, beyond that, we also said that it was undisputed that the cap, the HIP HMO, there's only one plan.
In terms of how you're reading that decretal.
Well, the decretal language doesn't talk about the cap at all. The decretal language simply says that the city has to pay up to the cap for any plan the retiree selects. It doesn't mention what that cap is.
Sorry, I misunderstood you. I thought you were saying there was something in the decision that you interpreted, and I thought this is what you were saying, you'll correct me, you interpreted it as a judge basically saying whatever the cap may be, it doesn't matter here, it's irrelevant in that sense, the actual number we put to that, because everyone agrees that senior care, right?
That's correct.
Doesn't exceed the cap, so I
Right.
don't have to address it.
And my only point was the court said that before the decretal language at the end of the opinion.
I see, okay.
And I mean, I could go on and on about the cap on the merits, but in terms of the preservation issue, I just think that here, in order to untangle all of the many tricky things that go along with the cap, it's impossible and unfair to decide that issue that affects the health of hundreds of thousands of disabled and elderly senior citizens and first responders when this issue didn't come up until the very last second. And there are serious issues, there are serious questions that the court would have to grapple with that it doesn't have the record to do so with. I'll note just two things here. One is the city claims that there has to be an apples-to-apples comparison. Well, there have been years when there have been multiple HIP plans that are HMO-style plans for Medicare-eligible retirees at different costs. How in the world could one of those plans set the statutory cap for Medicare-eligible retirees when there are multiple plans? By contrast, there has always been just a single plan known as HIP HMO, and that has been the cost of the plan for Medicare-eligible employees and non-Medicare-eligible employees and retirees. One other thing. There are situations where you have a family where say the retiree is Medicare eligible, but her spouse is not, or her child is not. Then you have a situation where you can't do apples to apples. You have a family of a mixed Medicare eligible and non-Medicare eligible. So it's never been the case that you can have apples to apples comparison, because there are situations where there's one apple and there's one orange, and yet you have to have one plan set as the statutory cap. Is it the apple or is it the orange? The city has no answer for that. There's a host of other tricky issues that this court can't grapple with, and we can't really adequately get into because we were denied the opportunity to do that below. And I don't think it's fair to the retirees here and elsewhere to decide something so important when the city chose not to actually develop that below. And I think the reason why it chose not to make that argument below is because it knew it was a loser. And for it to try to create a new argument after it read the signs at oral argument that it was not going its way, I think that's a dangerous precedent to set. Thank you, Your Honors.
Thank you.
I just want to start with the cap, if I can, and then I'll
Can I
circle-
just,
oh,
on preservation with
sure.
respect to the cap, can I just ask you, so your letter at page 1970 to 71, I take it that rests on the interpretation of the word category and the argument you make in your brief before us, you say, is that right?
I'm not sure how much it actually rests on category as much as it rests on what I think is just a very simple point that
Okay.
the
But-
apples to apples point that he can't basically.
Your common sense point.
Yeah, exactly.
Okay, and I
That's
take
my
it.
recollection of it.
Okay, this is the first, you agree with your adversary that this is the first point in the litigation in which this specifically is raised, or the 750 number specifically is raised? Is that?
I agree with that.
Okay, thank you.
I just want to, if I talk about the cap a bit, I mean, I think it's actually a quite easy question. And just as a reminder, when we talk about this, our plan would be to provide 2 free plans that, and one of them is based on mirroring the benefits of senior care, and then to allow senior care to be available on an opt-out basis. But it's very simple. If you look at page 1293 of the record, this is a document they put in and relied on, and drew numbers specifically from. What you'll see, there's a line at the top that says HIP HMO. It says non-Medicare single HIP HMO and Medicare HIP HMO. The cost for non-Medicare is $776. The cost for Medicare is $181. It's both HIP HMO, that's what the statute says. One is for non-Medicare, one is for Medicare. It's about 1/4 of the cost. It then goes on 1294 to say the following. A retiree who elects basic medical coverage other than the benchmark HIP, that's HIP HMO, and GHI EB CBS, that's senior care plans, is required to contribute the full difference in cost. And then, so it says anything other than those two, and I'll get to the senior care piece of that, you have to pay the full difference in cost. It does not say that anything under the HIP HMO for non-Medicare eligible, which would be every Medicare plan we offer, because that's an enormously high number for a Medicare eligible plan.
But
it doesn't
was
say
not
that.
Until the eve of the decision in this case that you realized that they didn't agree with you, that it was this low dollar amount? Because it seems
I
so
was
simple.
I agree. I think we should have raised it earlier. I don't dispute that, and I can't say I understand why we didn't.
Not as much to litigation failing as to if this was such a simple bullet, right? That this was such a simple thing, you could look at this chart, and it really takes away most of the liability in this case. Why wouldn't you have raised it earlier?
I think it was a big mistake, honestly. But I do think it's just that simple. The other thing I'd commend the court to in the record on this are 128283, the bottom of our 1282 into 1283 that lays out this point, and then the Spoli affidavit, which is ECF number 61, which talks about benchmark plans and how to understand that in collective bargaining. It's clear that it's never been the HIP HMO for actives, which doesn't make any sense. I just want, if I could, just touch on some of the points on the first issue. I know that
Just briefly,
my light
your
is
time's up,
as
so
briefly as I
quickly.
can. Absolutely, you can have hospital by one company, one contract, and medical by another. That's what senior care has. Hospital by one, medical by another. That's what all 3 of the plans that you find in the Board of Estimate resolution had. When he talks about other parts of 12126 that use the word plan, those were all added by the state legislature more than 3 decades after the section we're talking about. It wasn't even the same legislative body. It was 3 decades later. The committee report, I think you have a complete beat on. That committee report was verbatim identical from before the law was thoroughly rewritten to after the law was thoroughly written. Didn't change anything, including, if we just take it out of the context of this dispute, one of the things Mayor Lindsay objected to was the idea that the first version of the bill said you could only get payment if you were a member of a retirement system. He said, that doesn't make any sense. They thoroughly rewrote it. They eliminated that, and yet the committee report still says it only applies to people in retirement systems. It is clearly not a committee report written to summarize the bill that was actually enacted. The 29B argument in the state law, I think Your Honor hit upon the point perfectly. First of all, that only pertains to Part B premiums. That statute doesn't have anything to do with the actual provision, the actual question of payment for health insurance that we're disputing in this case. It's, I think, quite telling that they would twist that law to say that only in a situation, the state law was saying only in a situation where you had a choice of plans, when you're looking 50, 60 years into the future, radically changing medical insurance circumstances, radically changing budget circumstances. That's the only situation the city could reimburse Part B. And in any event, our proposal is to have a choice of plans. The MAP plan, HIP HMO, and an optional opt-out senior care plan. So it doesn't present any problem under that statute.
Thank you.
Thank you, Your Honor.
Following these arguments, the court rejected the city's argument and held that the city must pay up to the statutory cap for each health insurance plan that it offers employees and retirees. The court specified through the city's health benefits program, the city offers retirees a choice of health insurance plans. One of those choices is senior care, the plan chosen by the vast majority of retirees. The court held that under New York City Administrative Code 12126, the city is required to pay the entire cost of whichever health insurance plan a retiree selects. I think we can all agree that this is the rightful outcome. Please let me know what you think about this case in the comments below. And if you like this video, please consider subscribing. Until next time, folks.